my lord, just on homework, I'm afraid we haven't been able to complete it over the short adjournment because the person from whom we need to take instructions is in Seattle and not in the office at the moment. What I would suggest would be a sensible course, given that I think neither side is saying that D3 is particularly important or this issue is particularly important, is if we try and make progress in agreeing an approach with the other side, and if it's not possible to do so, then perhaps we might send my lords a note on this to see whether it can be taken out of play, if that's an acceptable course.
My lord, we haven't been able to take instructions either because my instructing client is abroad on business. He's in a meeting, basically.
Right, so
I assume you would have no difficulty with the common approach being taken in IP cases, viz. That there is no admission of joint tortfeasance by the parent company, but to avoid dispute, the parent company accepts any liability that there may be.
My lord, we would obviously have to look seriously at any offer that were made, yes.
But that would protect your clients, wouldn't it?
My lord, subject to those instructions that I take, yes.
Right, I mean, Mr. Edinburgh, let's not delay this. You try and agree something with Mr. Alexander. If you do or don't, you have liberty to put in a paragraph saying what the position is on both sides. Okay, but it's got to be by Friday evening at the latest.
Yes.
Hell or high water.
Yes.
Thank you.
Can I then just in the light of that, can I just very briefly address my lord in relation to the other points, because it may all be taken out of account. Just in relation to the copyright point, just to follow my Lord Justice Arnold's point, of course, although it's right that some of the copyright notices are Amazon.com, a number of copyright notices are Amazon.com Inc. or its affiliates, and the page references are 52, 53, 59, and 64. So it's another reason why one shouldn't read too much into this issue. The second point, just on this issue of joint liability, which was found by the judge, and again, my lords may not need to turn this up because of the approach, is that in paragraph 203, the judge found, as a matter of fact, that from the evidence it's reasonably clear that the operator of the website is not the third defendant, but one of its many subsidiaries, Amazon.com Services LLC, as one would expect. And the simple fact of the matter is the claimants have not sued the correct entity in relation to the allegations of targeting. Not good enough simply to point the finger of the ultimate holding company to allege that it must have been involved in some way. In all respectful submission, where there is a specific company, which is the operator, it's not good enough simply to come along and say, well, there's another holding company that may have been involved in some way. Final point in relation to that issue is on the data issue that was developed in argument. And again, we respectfully submit that simply being involved as a conduit for data, potentially masses of information relating not specifically to these products, but potentially products and individuals in many countries, if that is the position, is not a basis for saying that there is a sufficiently specific common design to commit any of the torts in question. If I could just very finally on this point draw my Lord's attention to the manner in which this was dealt with by Lord Sumption in the Supreme Court in the Sea Shepherd case, which is at tab 7 of the authorities bundle at 202 to 203. And he referred to the judgment of Lord Templeman in the CBS and Amstrad case between 41 and 42. In that case, at the end of the quote, what was said, generally speaking, inducement, incitement, or persuasion to infringe must be by a defendant to an individual infringer and must identifiably procure a particular infringement in order to make the defendant liable as a joint infringer. And so, in our respectful submission,
you have to read the qualification.
No, I understand that, and I'm going on to that. Going on to that. I don't think that in this passage, Lord Templeman was seeking to limit liability as joint tortfeasor to cases of inducement or procurement as opposed to assistance. When read with his general statement of the elements of liability of joint tortfeasor, clearly he was intending to limit it to cases of common intent. Using or procuring a tort necessarily involves common intent if the tort is then committed. Mere assistance may or may not do so depending on the circumstances. The mere supply of equipment which is known to be capable of being used to commit a tort does not suggest intent, other circumstances may do so. In all respectful submission, in cases of this kind, one has to be careful where one draws the lines between what might be called very general underlying infrastructure that may be used by a undertaking that is said to be acting cautiously, and combining with a particular undertaking to engage in acts of infringement that are specifically identifiable in that context.
Well, as a general proposition, that's a point well made. But what do you say about what Lord Assumption says at paragraph 38 on page 201, where after the quote from Vestergaard that Mr. Edinburgh drew attention to, he says a person may incur liability as a joint tortfeasor by assisting in the organisation or preparation of acts of physical destruction, helping the primary actor to find the victim by whom he intended to attack, or, and this is the one I'm interested in for reasons that will become obvious, by using the prospect of unlawfully downloading streamed copyright material to attract users to the defendant's website.
Yes, well...
Citing my decision in Dramatic.
Yes, indeed. We respectfully submit that there is a common feature in all of those, which is that there is a sufficiently specific, albeit of varying degrees of specificity, common design in all of those cases. Each of those cases turns on its own facts, and one of the key messages we would submit from the Sea Shepherd case is that these kinds of cases are very fact specific and fact sensitive, and we would respectfully submit that one can't simply say, well, because in some other particular context where there may be a specific intent to create a website that enables the downloading of copyright infringing material. In those circumstances, one might say, well, one doesn't need to identify a specific potential infringement or work in order for there to be a common design with respect to that. But that, in our respectful submission, is a very different situation where there is simply a facility provided where very occasionally there may be an issue that arises in relation to an intellectual property right. The fact that an undertaking is involved at some point in that process doesn't mean that it is right to hold that they are jointly liable in those circumstances. So in our respectful submission, those are all cases which are illustrative of the general principle that was reflected later on in Lord Sumption's decision, and they support our approach. So that's really all I want to say about B3 and joint liability. Can I then come to the final point, which is remedies? And the first thing that I need to do on that is either apologise or say some words in defence in relation to authorities, because my Lord criticised, I think, both me and my learned friends for not citing the relevant authorities relating specifically to the what I regard as the Burger King point. My Lord may know what I mean, others may not. Burger King was the original locus classicus, where the Court of Appeal said there are some situations where the court can see already at the end of the trial, having gone through the whole process, where a party has had their day in court, and indeed quite often many days in court, that a inquiry as to damages would not be a fruitful exercise, and the discretionary power was established to say, well, there shouldn't be an inquiry in those circumstances because, in broad terms, the case is not worth the candle. Now, just to explain to my lords, just in a way in defence of my learned friend, of my predecessor, Mr. Mellor, and those behind me, and indeed the judge, the matter was addressed to the court, as my lord, I think, anticipated that there were oral submissions in relation to this, and we can... Was
his attention drawn to these authorities?
No, his attention wasn't drawn to these...
In which case, what was the use? They were binding on him, so, I mean, any decision he made was per incuria.
If your lordship will just bear with me for a moment, because my submission will be, and I hope to make it good with references to the transcript below, that his attention was drawn to the principles, albeit that his attention wasn't drawn to the specific authorities which articulate those principles. Indeed, my learned friend, in my respectful submission, correctly articulated the very principles which the judge went on to apply in the passage where he dealt with remedies. If my lords would be prepared to let me hand this up, I can show your lordship where that happened.
You send it electronically, please.
Yes, we'll ensure that this is all put into the electronic bundles.
Or just send it separately.
Yes, of course, my lord. So this was at the end of day 5 of the trial, and sorry. If you look at page 72, so it's the bottom right of the first page, Mr. Justice Michael Green says, so if I say, found them liable, but only in respect of, say, the historical breaches that they've admitted in their 30th November letter, do you say that even in respect of those two, those breaches which are historic, and as we know didn't give rise to many sales at all, that it still has to go off to an inquiry as to damages? And Mr. Edinburgh says, and in my submission correctly, my lord, the case law on this is relatively complicated, but in short it is that there is some case law which says you can make, in essence, a procedural decision, then saying it's not worth the candle and therefore not order an inquiry or an account. And then the judge comes back, if I thought it was disproportionate to or the likely result, any such inquiry would be de minimis. Yes, exactly, you make a judgment call at that stage and then exercise, in essence, a case management power, so to speak. Right. And then Mr. Edinburgh says the normal way is that you would order what's so-called idle records discovery, whether some limited disclosure, and so forth, and the judge comes back and says, do you consider it would be appropriate to consider those issues at a sort of consequential hearing? Yes, together with, if necessary, some evidence to work out what my judgment means and whether it should actually go to a proper inquiry as to damages. Yes, and so forth. So the outline of the law, which I will show my lords, was in my respectful submission correctly outlined, and the basis for that is in the Burger King case, which again, if I may hand that up, and it will be supplied electronically to your lordships. Where the Court of Appeal was considering whether or not there should be an inquiry as to damages, and considered that there was discretionary power not to grant an inquiry. That, I think, is the primary case that my lord was perhaps thinking of that you thought ought to have been cited, but I may have...
The first of the two Court of Appeal decisions.
I may have got that wrong. In any event, I've only brought that along because it articulates that principle. And the other case that I've brought along, just to show your lordships an application of that principle, in a case called Emanco and Electrolux and Dyson, where there was a trademark infringement case about comparative advertising, and the court applied essentially McDonald's and Burger King to say that there shouldn't be an inquiry as to...
Although, of course, in McDonald's, what happened was that the first instance judge refused an inquiry, and the Court of Appeal overturned him because it couldn't be said that it would be fruitless.
My lord, but the point in my respectful submission is that the principle and the approach was correctly articulated in the authorities, and my lord, I know, has applied this in other cases, or said, well, I'm going to evaluate damages summarily instead of instead of having a full inquiry as to damages. In the Imanco case,
Well, let's look at the statement of principle in McDonald's first of all.
yes. So, in my submission, the principle is that there is a discretion that the court has to refuse an inquiry in appropriate cases, and that is articulated at the bottom of page 118 in the judgment of Lord Justice Fox.
If the plaintiffs have an arguable case for claiming damages, the court would, as a matter of ordinary justice, make an order for an inquiry to enable them to pursue it.
Indeed.
So it's effectively, to put it in contemporary terms, real prospect of success in recovering damages.
Indeed, but the court also considered that it was appropriate to consider a proportionality.
I don't think proportionality came into it at this time. It certainly comes in later. Does it? I don't think they said anything about proportionality in this case, did they?
Right. Well, if your lordships go on to the judgment of Lord Justice Carr, where the principle was also articulated, he said at 122, I've come to the conclusion that while in some circumstances, what has already referred to the words of Lord Sunderland Sporting Gamage, the court certainly has the discretion to refuse an inquiry. This is not a case in which that discretion was properly exercised. May well be a weak case, but that's not the point. In my respectful submission, that there is a discretion which the court has. It's not a situation where an inquiry as to damages has to be ordered as a matter of right. The court can, as my lord indicated in argument, do one of three things: order an inquiry as to damages, refuse an inquiry as to damages, or say I'm going to evaluate the damages summarily, or that there is a further option.
Would you accept that the judge was not alerted to the third possibility?
I think that is right. At least I haven't found any documents which did alert him to the third possibility. There is, in fact, still a fourth possibility, if I may say so with some diffidence, which is that the court can say, we are going to permit either summary assessment or an inquiry, but we're not going to allow you to do it until you've attempted to resolve this in a non-litigious way. And part of the reason I say that is because there is a move to try and encourage parties to resolve matters non-litigiously if possible. And one might say that the more it appears as though the sum in question is not going to be a significant sum, the more satisfied the court should be that adequate steps have been taken to resolve the matter non-consensually before it will authorise the continuation of what is potentially a further legal process.
Yeah, well, that's a very fair point, and I think it does receive a degree of anticipatory support from the decision in Reed and Reed. I don't think that specific possibility is mentioned, but that kind of thing is clearly contemplated. But to come back to the present case, on what basis do you say that the judge was entitled to conclude that the financial remedies to which Lifestyle were entitled were zero?
Well, let me show my lord what the judge said about the concerns that Lifestyle had expressed, because this is a very unusual case in which the issue that Lifestyle has raised is not really about sales or indeed even offers for sale leading to sales. The issue that Lifestyle had raised was the fact that its licensees or potential licensees could see the fact that the goods were available at a lower price in the United States.
More specifically, they contended, and I emphasise the word contended, that they had lost potential licenses as a result, and therefore had lost income streams as a result.
Indeed, but my lord needs to think a little bit about what the incremental value is of this, because let's suppose that the damage is damage as a result of potential licensees knowing that these goods are available in the United States for a lower price. That is something that is public information. In some senses, it's got nothing to do with whether or not the goods are sold in the United Kingdom at all, or indeed advertised in the United Kingdom at all. It's simply a fact that they're available in the United States at a lower price. So the court would need to consider what the incremental damage would be.
So where does the judge engage in a legal analysis of that question and conclude that as a matter of law or fact there's no causation and therefore there's no damage?
Well, he doesn't engage in that detailed legal analysis, but in my respectful submission, it's not necessary in refusing an inquiry as to damages to engage in that level of detailed analysis in circumstances where effectively it is common ground that the mere fact of sales would not justify a inquiry. The mere fact.
Common ground. It's common ground that the mere fact of the sales that were admitted to be infringements were small would not make a full inquiry proportionate, or at least I'm not sure Mr. Edinburgh accepted even that much, but I think he would resist that less strongly, if I can put it that way. But it doesn't lead to them getting zero. It leads to a small sum of damages.
Indeed, and I follow where my lord is going on this, but my lord may say that in my submission it is reasonable to say that where one has a sum of damages in the context of litigation of this kind, which is really so small as to be kind of within margins of costs error, if I may put it like that, then to say, well, there shouldn't be an inquiry as to damages is a reasonable and proportionate thing to do. My lord may say, well, in those...
Suppose, for the sake of argument, that damages were £1,000. Small claims track stuff. But why are they to be denied their £1,000?
My lord, I'm not going to, as it were, fight that point.
That's what the judge has done.
My lord, he has, and he has said, well, look, if that is what we are concerned with, damages at that level for this kind of alleged wrong, then it's not justifiable to have the full apparatus of an inquiry as to damages.
To be sure, but then you have a summary assessment. But the judge wasn't alerted to that possibility, so he didn't even consider it.
My lord, that is right, and in retrospect, one might have done that, and I know my lord has in other cases actually ordered the financial relief and liability to be heard at the same time, just partly to roll all of this up in one.
That was an exceptional case.
That's, I'm not saying that's something that is ordinarily done, but we're concerned with two aspects, and I take my lord's point, of course. Even £1,000, lifestyle shouldn't be deprived of their £1,000, but that's a question, in my respectful submission, for a discretionary evaluation by the court. If the court is, if the real casus belli is complete invisibility of the marks, and a claimant says, well, I don't really, I mean, I kind of care, but I don't really care about the minuscule sales. Then to say, well, we're not going to have an inquiry as to damages in relation to something that you really don't care about, if complete invisibility of the marks is not something that is realistically achievable, in the sense of that it's not possible for someone to even see a site that says these marks are being these goods are being sold to the United States up in big banners, and these cannot be delivered to the United Kingdom. That's the real casus belli in this case. And if my lords say, well, actually, there ought to be a summary assessment in relation to damages, so be it, or some other course. But we respectfully submit that if one is to encourage sensible cases to be brought and slightly less sensible ones not to be pursued, it's not unreasonable to say, okay, now you've made your point in relation to this, damages is not really the issue, there shouldn't be an inquiry as to damages. And that's what the judge did in we respectfully submit a sensible case management way. If the court is taking a different way to say, well, it doesn't really matter whether we're dealing with £1,000 or £10 million, an inquiry is always the appropriate course, then so be it. And I accept that if that's the approach that should be taken in a case of this kind, then the judge didn't take that approach. But we respectfully submit that
Well, we're bound by Burger King anyway.
Oh, indeed. But Burger King is only setting out principles.
Yeah, but the principles are that there's a discretion.
Exactly. That's my point.
Yeah.
And that was...
We've got it. A long 10 minutes, Mr. Alexander. But thank you.
I apologise.
That's all right. Mr. Eden Graham.
My Lords, I was going to endeavour to deal with the points in the order in which they turn up in my learned friend's submissions to your Lordships. I've only got, I think, 8 points or so to make. The first of which is that with respect to these other factors that are being talked about, for example, the visitor numbers or what have you, in my submission, those are factors that you could take into account, but really only in marginal cases. If you look at the Merck case, right at the end, the part that's highlighted, you'll see that those turn up in the 4th category of things that you look at. And in that essence, we say that they should therefore be delegated to the bottom end of consideration. I mean, it touches upon the Greenland point, because if, for example, everything points to adverts being used to attract customers in Greenland, but actually nobody has looked, all that means is that the effort has not resulted in any positive success. It doesn't actually deny that they were striving but failed to use the mark in Greenland. So it might be relevant in some circumstances, the visitor numbers, but it's not determinative. The next point touches upon my learned friend's Macy's example. And the way in which this turns up is if you look at the supplementary bundle behind tab 1C at page 30, what you see here, this is at a very early stage of when you're going through the whole process. So there's no search yet for any particular trademarked goods. But what one has done is click on that little icon in the top left which says deliver to the United Kingdom. And it opens up a box that says we ship internationally. We're showing you items that ship to the United Kingdom. See items that ship to a different country, change your delivery address. And the reason why we say that is relevant is that when you then go forward to, for example, the advert at page 116, you'll know that that advert, therefore, is for something that may be shipped to the UK. And so therefore we say that everything post that page where you read that icon is being pushed to you. And in the context of the Macy's example, this is like walking through the store, the ground floor store in Macy's, where everything is available for everywhere, so to speak. But you go to the third floor, and above the third floor entrance it says, these are items that are aimed for people who are foreigners, in particular those coming from the European Union. That's how he put that point. And so therefore it's a push at that stage with respect to those adverts. The paragraph 155 of Merck Authority, which is Authority 8, page 261, it's important to take from that that what is considered to be relevant use is use that manifests the intention of the trader to establish commercial relationships. And so that's, so to speak, the touchstone for relevant use and gets around all this issue of targeting. Then move into the second ground of appeal, the Blomquist point. My learned friend put forward the proposition that in essence, if there's a sale, he was trying to draw the distinction between a sale per se and an advert or an offer for sale. With respect to an offer or an advert for sale, you needed this targeting requirement, but seemed to suggest that the claimant's view is that if there are just a simple sale, there's no need for targeting. In my submission, no, our position is that what makes the sale judiciable within the domestic jurisdiction is that that sale is to a person in that local jurisdiction. That's the thing that links it. It's not just a sale to somebody at large, anywhere, somebody in the Solomon Islands or what have you. It's a sale to a person in the EU. And that's the, in essence, link that forges and allows the jurisdiction to be exercised. On the third ground of appeal, the importation point, there's the first point here is that my Lord, Lord Justice Arnold, said that the concept of a free circulation was an EU concept, and it arises from Article 29 on the Treaty of the Functioning of the EU. And if I may just read it out, products coming from a third country shall be considered to be in free circulation in a member state if the import formalities have been complied with and any customs duties or charges paid. So the long and short of that is, in my submission, it supports my contention that importation, once you've paid any customs dues or levies or what have you, those goods are then in free circulation. It's not that you need to pay the customs duties and then put it into free circulation. There is only one act, so to speak, the payment of the duties, and the consequence of that is that the goods then fall into free circulation. There's another point with respect to the importation ground, and that is that we say what you need to do is look at the acts, the relevant acts. Now, it might well be that the terms and conditions say that the customer is the importer of record, and actually we say that's probably quite a deliberate choice of words. It's the name that appears on the importation documents. But the importer who's actually doing the importation, we say is the commercial importer. And that's all you need to really look at. Now, there might well be a relationship between Amazon and, for example, UPS, but that's going to be a contractual relationship between them, and they can sort out their various risks as between them in their contractual arrangements. But that's nothing to do with us, we say. It's just all of this argument, by and large, we say, is irrelevant.
Are you able to assist us with regard to the question I was asking Mr. Alexander about this morning, because when it turned out that he was contesting the proposition that UPS was the importer within the meaning of the trademarks legislation, I asked him whether there was any authority on that point. He was unable to think of it. Can you do any better?
Well, I would refer you to cases like AVB, Class International itself, and Peak Holdings, where it's absolutely clear that the actual importer is being considered to be the importer. There's no sort of, I'm sorry, it's tautological, but that it seems to be just blindingly obvious to me that the person who's doing the importation is the importer. And to address my Lord Justice Snowden's point about the BA example and the passenger, is that BA is not the importer because, as we all know, you get off the plane, you go and pick up your luggage, and then you go through anything to declare, i.e. customs.
Yeah, but why is UPS the importer when Snooks in New York rings up UPS and says, "Can you take my branded goods to London?" The importer is obviously Snooks.
Well, he's the principal. Mr. Snooks is the principal.
I mean, it makes no sense to make UPS liable for trademark infringement, does it?
Well,
I mean, that cannot be right.
Well, it can be right, my lord, for the following reason, is that the Act simply says the wrong is the importation.
I know what the Act says.
Yeah, yes, but I'm pinning it down to the legislation, my lord.
The importation would never have happened if it weren't for Snooks in this example.
Absolutely, but that's irrelevant.
Is your analysis that UPS is the importer, but Snooks in the example is jointly liable with him jointly liable with UPS if there's a trademark infringement involved?
No, there might be another problem, and that is Snooks might not have committed any act in the course of business.
No, I mean, Snooks hasn't committed.
Yes.
That's my whole point.
Yes, well, I mean...
Is that it makes absolutely no sense to create a trademark infringement when a private individual perfectly acceptably, not in the course of business, moves goods across borders simply because the word is importation. The importation in the course of business is not referring to the act of importation, it's referring to an act in connection with the use of the mark in the course of business.
Yes, my lord, but the point about that, the importation has to be under the mark, and that phraseology means that the goods are branded. And if you are doing the importation of branded goods in the course of business, which is what UPS is doing, that's importation, full stop.
I mean, this is your weakest point, and it doesn't matter if you're right about the others.
Well, it's not my strongest point, my lord.
Well, I'm grateful for that, but the point I'm making, just
sorry,
to finish, the point I'm making is that if you're right about the others,
its significance falls away.
its significance falls away.
Well, to be more precise, suppose, if upon due reflection, we come to the conclusion that you're right on targeting and right on sales, is it not then the case that we don't need to decide the importation point, because that then becomes academic?
Might I very quickly take instructions on that? Because I'm fairly sure I'm going to have to agree with you. My lord, the reason I took instructions is because it is quite an important concession that I'm now giving. If I win on grounds 1 and win on grounds 2, then ground 3 falls away.
Thank you.
But obviously I don't know where you're going, so therefore I still need to
certainly
maintain.
don't, Mr. Edinburgh.
So
But we've noted the concession nonetheless.
yes, exactly. I know I'm being held to it, but I'm still running it, and
I understand.
Yeah, my lord. Okay,
I mean, for my part, I think it's an extremely complex question,
my lord.
which would be better decided in a case which actually, where the facts were really about that and nothing else.
My lord, I fully understand. In which case, I will definitely move on. The grounds 4 to 6, as you know, were taken together, and I'll deal with it incredibly quickly. The copyright notice on page 54, the reason why that's important is because it says D3 only, and not, for example, D3 and its affiliates. And it's dated 1996 to 2020, which I think, at least on my reading of the evidence, is the latest date that occurs on any of the evidence. And
I mean, you said we should go to page 54.
Yes, sorry.
Yes. If you go to page 53,
Yes,
as I understood it, that's the same. It's at the same time. It's just the earlier, as it were, homepage where you have to log in. You've got your sign in.
yes.
But
And there it says, and its affiliates.
yes. So, is there any real rhyme, reason, or rationale behind the use of these two expressions, Amazon.com Inc. or Amazon.com Inc. or its affiliates, or is it just pretty random, which they put on the bottom of the
I
particular
hesitate to
web
say
page?
random, but I have failed to discern any method.
Yeah.
That's as far as I can go, my lord.
You can't
It's
speak-
common.
You can't speak for them anyway.
No, it's common if you look at, I mean, I've read, there's literally tens of lever arch files of this. And it's common for it's to say a certain named individual and or its affiliates, open parentheses, Amazon. And then it goes on and talks about Amazon. And it's just a different named person. This is in different contexts, if you see what I mean. But that's
Yeah.
the way in which they often do it.
Yeah, I mean,
But that notice identified D3 solely without any indication of its affiliates. And that's an assertion, and we rely upon that assertion. And the reason why it then feeds in to the conditions of use is that at page 60, you've seen this already, but I think again it was a point that my Lord Justice Snowden raised, was that it also appertained to the software, not just, for example, the copyright and the various notices and what have you, the web pages and the strapline. I think you mentioned expressly the strapline, but the software obviously is the underlying mechanics of the operating system. Sorry, of the website.
I mean, that's expressly said in the middle of page 60, is your point, under the heading copyright.
Yes,
Yeah.
sorry, my lord. There was a point that came out in discussion with my learned friend about what you could or could not currently see. And the point being is that the equivalent to page 116, you can still see if you're using the business model of fulfilled by merchant. But with this, and then at a later stage it says that you cannot ship because one of the items has a problem, doesn't identify which item, and then it gives you the 10 generic reasons why there might be a problem.
How do you move between business models?
How do you move between them?
Between them, yes.
Well,
Or just a user?
If you're a user, it's not the way in which it's set up that you as the user move between them. It's that some things are sold by different business
Right.
models.
So you don't actually know how they're being sold.
You get a choice, don't you, sometimes, of if you want to get it from a particular vendor or a different vendor, you can click on different.
Yes, but that might not distinguish, my lord, between, for example, fulfilled by Amazon and fulfilled by merchant.
No, I mean,
Because
sometimes on Amazon it says, do you want to get it direct from ABC Co? But it won't tell you, it's not telling you that because to get you to choose a business model as
No.
such. It's just telling you that for delivery purposes, really.
Well, that's identifying the vendor,
Yes.
but it might not identify whether it's a fulfilled by Amazon business model, whereby a third-party vendor sells, but Amazon does everything else, or fulfilled by merchant, where the merchant is the third-party seller and does a lot more, and Amazon only does a lesser extent. It's involved to a lesser
Might not
amount.
distinguish between those two, but it might very well distinguish between sale by Amazon.
Yes, either the global or the... Oh no, that doesn't work. Export. Export is where Amazon own the goods. That's the clearest example, my lord.
Yeah.
We didn't, when we pleaded this, we didn't actually know there were 4 business models. That all came out in the defence, you'll see that.
You might be able to surmise, I suspect, because from memory, again, when you get down to the delivery options, I think you have, again, different options to select.
Well, there's a difference between fulfilled by Amazon and fulfilled by merchant with respect to, for example, you know, the you can't get the packaging option, the gift wrapping option, for example, in fulfilled by merchant, and also the estimation of the import duties and such like.
It's the latter one that I was thinking of.
Yes,
That's an express carve-out. We saw that yesterday.
Yes, exactly so. So there are differences, but you need to read the fine print to be able to ascertain it. And there's also a difference in the guarantee, the way in which the guarantee works.
Yeah.
Well, the way in which guarantee is worded, I think, is probably the most I can say to you. With trepidation, I enter upon the 7th ground. You've seen the exchange between me and the judge. I thought what was going to happen, and I thought this was fairly clear, was that the judge was going to hand down a judgment and say we'd won or lost on whichever grounds.
Come and do some consequentials.
And then we'd come back for the consequentials.
That's what you said.
And we got the judgment. As is absolutely crystal clear, we lost on pretty much everything. Well, we lost on everything that was still in contention. And so what was really left for the consequentials was costs and permission to appeal. Costs we argued about, we lost again. Permission to appeal, he granted all 7 grounds, pretty much without any argument. I wasn't there, but that was the report back that I got. We can still be faulted to say that we should have done a barrel.
This is really not about fault,
Right.
Mr. Eden, but don't trouble with it.
Right.
This case has been properly argued.
My lord.
There may have been errors and omissions, but there are in even the best regulated of litigation.
My lord, I'm grateful for that indication. My lord, I've hopefully been under 30 minutes.
You have. Thank you.
Only by your grace, by not
Anything else?
asking me any more questions. My lord.
Well, thank you both, and thanks to your juniors and instructing solicitors. It's been a very interesting argument, and we'll take time to consider our judgments. When we do, will you please, we'll hand down the judgment in the usual way, but under a new embargo, which I would be grateful if you take very seriously. You may have seen the case of Counsel General for Wales, and it's very important that the embargo is not breached, because if it is breached, contempt proceedings are now likely, inevitably, to follow. That means that you need to be very careful, particularly in the corporate situations of this case, to make sure that the embargo, that the judgment is not shared beyond the absolutely necessary people for the purposes set out in that judgment, which is not wide, as you will see. Subject to that, though, when you have the draft judgment, please try and agree in order. Please tell us any typographical but not other corrections. And if you can't agree anything, heaven forfend, we will deal with matters in writing, not orally. That should be enough for today. Many thanks again.